Okay, so I've started recording this call, which will then be placed in social media. Please don't raise your hand. Put it down. Press *5 again. Don't raise your hand. I'm going to first address the questions that have been posted. I'm also going to lock the conference so that we make sure people who are here. Let me hold on.
The conference is now locked.
So now we are only going to address the questions that have been posted and then new questions for people who are already in the call. Good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna, PC. Today is November 7th, 2024. This is our Thursday community conference call. We have one every Thursday, once on LinkedIn and once on our conference bridge, which is where you are today. You heard the disclaimers when you logged in. All of them apply. The call is being recorded. It will be placed in social media. Okay. So I'm going to go to the questions that have been posted in our forums, forums.immigration.com. In these, there are some that I have marked as frequently asked questions. So this will be the format of our call. First, I will read the frequently asked questions, answer them. Each time I answer a question, I will ask you if you have a follow-up on that. Please don't ask any new questions, only follow-ups. Then I will go over the other non-frequently asked questions that have been posted on the forums. Again, I'll ask each time if you have a follow-up question. Once we are done with that, in about half an hour typically, I will then open the call for any questions from anyone on any topic. Okay? And I will then start answering those questions roughly in the order that you logged into the call. Starting with the first frequently asked question, this is about H-1B layoffs, 60-day grace periods, visa options, and transitioning to study. H-1B, does it start on the date of getting notice, or on the date of the severance paycheck, or on the last date of the regular paycheck? So the government has never really addressed the issue of severance. Okay. The way I see it and the way I would argue it is, the 60-day grace period begins on the day after your last pay period for which you were paid, or the last date you worked, whichever is the latest, last. Okay. So let's say I stopped working on October 31st, but I received paycheck till that covers the period until November end, but the actual paycheck was received on December 15th. So we have 3 dates now. We have the date I stopped working, which is November 1st. We have the date that I was paid for full salary, which is end of November. And I have the date when the check was actually received, which is December 15th. Your 60 days will begin December 1st. Why? Because the last pay period for which you were paid ended end of November. Even though you received the paycheck on December 15th, that paycheck covered you only till the end of November. I hope that's clear. Okay. The severance issue, they've never really answered. What if instead of a regular paycheck, it's a severance paycheck? So I would try not to go into that gray area if I can. You see, as lawyers, we have to think about practical solutions rather than theoretical options. So my inclination is always to take the safest path and avoid even the gray areas if I can. That's what I would recommend. During H-1B 60-day grace period, what is the best time to apply for B-1, B-2? So this is what I have said in our frequently asked questions many times. I've said, folks, if you are applying online, then I would say about 55th day of the grace period is okay. If you are applying by mail, maybe the 50th day, 50, it gives you enough of a leeway that if something goes wrong, the FedEx gets misdelivered or the UPS gets misdelivered, you can always refile. So I like to keep a little bit of gap there. Okay. So that's what I would recommend. Now remember one thing, If more than one person is applying and you do it online, it's very expensive. But if you do it by mail, you only pay the fees once, like for husband, wife, and children. Okay? That's kind of how it works. Then the next question here is H-1B for 6 years of work or 6 years total? I mean, does unemployment time or B1, B2 time, etc. also count? And the answer is B1, B2 doesn't count. But the 60 days of grace period do count towards your H-1B. Okay? So the moment that 60 days is over, your H-1B clock will stop running. After layoff on H-1B, if I decided to go to school, how to stay in the US until getting admission decision? That could take months. Well, B1, B2 is the way to go. And if you are still in status or the 60-day grace period and you apply for a change of status to F1, you can actually remain in the United States until you get a decision. So there are some options there. After layoff on H-1B, what is the better option to choose, B1 or F1? So that depends. What I tell people is, if you think you are rather going to study than work, then just go for F1. Why delay it? But if you think that eventually you rather would work than study, B1, B2 appears to be an okay option. I would rather then go for B1, B2. So if you want to study rather than work, then just do F1. Otherwise, do B1, B2. Okay. Press *5 if you have any follow-up question on what I just talked about. Please press *5. Okay. I have one from area code 510, which is California. California, go ahead. I can hear you.
Hi, Rajiv.
Hello.
So my question is, like, you have told the transfer from B1, B2 visas and also to F1 visa, right?
Right.
So, I mean, if we shift from B1, B2, and if my B1, B2 is approved, and I want to join my school in August of 2025, so how could I do the transfer now? If laid off, I'm on B1, B2, and my B1, B2 is gonna end in March or April. And if I've got my I-20, which is a valid I-20, so how could I cover the gap without getting an extension of B1, B2?
Yeah, so you know that you have to apply for a change of status from B to F to join school.
Yeah.
So if within the life of your B1, B2, you apply for F1, I think you're going to be okay.
Okay.
That will cover you from March or April to August. I think you'll be fine. Okay.
So is that looks good on USCS, on my books? I mean,
there's nothing wrong with that. So now again, under Trump administration, God knows what they are going to do. But under Biden administration, they said if you file for an F1 change of status and you were still in status and then you fell out of status because the old status is gone, because your F1 is pending, we don't consider you to be unlawfully present. So that means chances are you'll be okay. All right?
Yeah.
So,
other question is, like, to add on to this. Sorry. So going out of country, getting stamped again on F1 and coming back into US is a better option, or staying in B1, B2 in transition to F1, is that a better option?
So that I cannot comment, because I don't know how the visa office is going to look at your situation. If the consulate looks at your situation and says, well, we don't want to give a visa to an individual with this history. So that's a very uncertain thing. I can't predict that. But change of status is maybe relatively safer, right?
Okay, got you.
Good luck, ma'am.
Yeah, thank you.
Okay, let me go on to the next frequently asked question. So this was somebody who said they got a recent I-94 on which there is a notation. The notation says, note to employers, local, state, or federal agency granting benefits. Please visit the CBP I-94 website, click on the most recent I-94 to search for the applicant to confirm the travel information, etc., etc. Now, I have not seen that. This is new, and I had not even heard about it, but it looks like a very normal kind of nothing extraordinary about it. I have still haven't received any information about this, that they are going to change this notification or notation on I-94, but I don't think it's something to worry about. Yep. So is there any other question? Yeah. So the answer is this may be the new normal. I'm not worried about it. Press star 5 if you have a follow-up question on this. Press star 5. Next question. Frequently asked. H-1B stamping delay and admin processing in India, payroll gaps, reentry concerns, and expediting options. So this is, they are writing for a friend of theirs. Currently there's a challenge because they are stuck in India on a 221G for an H-1B. He attended the interview in September, responded to all the questions. He got another 221G saying that his case is now under admin processing. There's been no progress. So the friend's concerns are twofold. One, unpaid leave and payroll. Company doesn't allow him to work from there. His last payroll processed through August 15th. So he's still formally employed, but no payroll. Will his re-entry to the US be problematic? Once he gets his visa stamp, his re-entry should be okay, even if there's a gap in the payroll. Nobody's going to keep paying you while you are outside the US. Okay. There are some cases in the books that indicate that they should be paying you if they want to maintain the H-1B. But it's a very difficult question to decide, and their lawyers with the employer should decide. As far as the employee is concerned, you are doing nothing wrong. You are stuck there. You want to join, but you cannot. The fact that you don't have pay stubs is because the employer is not giving you pay stubs. And why should they? Because you are not working. Department of Labor may have another opinion about it, but that opinion I think is unreasonable. It's by an act of the government that you're stuck there. So I think it's going to be okay. Can this be expedited? Absolutely not. You can try having your employer or through your lawyers write to the consulate explaining the urgency of the situation, but 221Gs are hardly ever expedited. Press star 5 if you have a follow-up question. Press star 5. All right. Let's see if there's any other frequently asked question. I think we are done with the fact. Now let's do the regular questions. This is question number 3. Traveling internationally on a second master's. Visa renewal, H-1B lottery, uncertainty, and re-entry planning. Currently pursuing my second master's, having started in May 24th at Trine University. My initial 5-year student visa expired June 24. I plan to travel internationally to India and Canada. Is it a good idea to travel internationally while pursuing a second master's? That's so difficult to predict. Your first master was computer science, second is engineering management. It is difficult for me to predict whether you're going to be able to renew your visa. Nobody can give you any assurances on this. Okay. So they'll have to, basically it's the consulate's decision. That's all I can tell you. Remember one thing. If you travel to Canada for less than 30 days, that's perfectly legal and you don't need a visa. That's called automatic visa revalidation. You could travel on your AVR, okay, if it is less than 30 days. But for India, if you come back, you need a visa. There's no AVR from India. Press star 5 if you have a follow-up question. Press star 5. Question number, looks like 6. Re-entering the US on a green card after extended stay abroad, boarding issues, entry denial risk, surrendering green card, SP1 and visitor visa. Wow. Okay. My mom came to the US on a green card, went back to India in August 23, had some medical issues, could not come back. So that means she's been outside USA for more than a year. Can she still take a flight from India/UK? Or will she be denied boarding? She'll probably under the COVID policies, she would not be denied. But I think COVID policies are over. So I think the best thing you can do is check with the local travel agent to see somebody who's good to see if the airlines are going to give her a problem. Okay. If she's allowed boarding, can she be denied entry? Well, somebody has a green card, they'll allow entry, but they can lift the green card. And they can say, wait, you'll be hearing from the immigration court. You'll be put in deportation, which is okay. If she surrenders her green card when she lands, do they give her a visa? No, but they can parole her. I think that's risky. I'm not sure that is the best thing to do. Should she apply for SB1 visa? Very difficult to get. Extremely difficult to get. I don't know what is the best option here. Well, let's look at the options. Try to come as she is. She'll make it all the way to the airport. They can't turn her back. So that appears to be the best option. But if they won't allow her to board, then SB1 is obviously your choice. Or you can start a new green card process. Okay. Just simple logic. Press *5 if you have a follow-up question. Press *5. Okay, this is from area code 706. 706 is Georgia. Okay. Georgia, go ahead, I can hear you.
Hello, Rajiv. This is my question.
Sir.
I want a follow-up question. So my mom did not go with the intention to stay longer.
No, I understand that.
But
Rajanji, sorry, what happens is, if somebody is outside USA for 1 year, their green card is automatically deemed to be abandoned. They have to kind of reinstate that either through SB1 or surrendering and reapplying. Okay. So the question of intention is not going to be decided by the airline. The question of intention can only be decided by the CBP at the airport. Okay. Now you have another option. Remember, she can clear immigration outside USA in Abu Dhabi or in Dublin Airport in Ireland. So if you don't want her to fly all the way to USA and be turned back at the airport, you can always have her clear customs and immigration in Abu Dhabi or in Ireland, which is definitely far closer than USA to India. Okay?
Okay. Yeah, so she's actually already flying to UK for a conference.
Okay.
And she was going to take a flight from UK this month only.
Okay.
So do they have customs at UK?
Yeah, not UK, Ireland, Dublin Airport. Dublin Airport. Yeah. Okay.
Okay.
Which is very close. It should be
right.
less than an hour's flight, I think. Okay.
Okay. So once she lands, then the CBP officer may deny entry or...
Yeah, so what happens is, if they are not going to let her enter, and I know that actually Dublin is pretty tough, and so is Abu Dhabi, they can tell her, look, we're not going to let you enter. But if she's already in USA, they will let her enter. That's the normal thing. Okay?
Okay, thank you.
Good luck. Okay, then let's go to the question number 7. Applying for F1 after B2 extension and F2 denial, impact of previous visa history, change of status versus consular processing, and requirements for owning a consultancy. Wow. I was earlier denied an F2 in 2018. Then I got a B2, visited my spouse multiple times. Currently I'm in the US with first B2 extension approved, ending in January 25th, first week. I assume this is next year, right? I got selected for a master's program starting March 25. Will my earlier F2 denial or B2 extension create any issues for my F1 approval? I don't see F2 denial. No, that's just a visa denial. That doesn't affect your USCIS application. B2 extension, well, that's up to the council, to the USCIS. It's hard for me to predict. I don't think they'll make an issue of it. My spouse is on H1B after H1B B2 as he was laid off. No, I don't think that should be an issue. Should I apply for conversion within USA or go for stamping? Look, if you apply for a conversion, which is change of status within USA, and you're denied the conversion, visa stamping is the only choice. But if you just give up and go for visa stamping, then you are foregoing an opportunity of at least trying here first. Okay. I have a consultancy practice firm registered in my name as a chartered accountant. Do I need to close it before applying for? No. Can you continue it? No. I don't think that's possible. But do you need to close it? No. That is not required. But in my view, working on the US soil, even for your Indian operation, could be problematic. Government has never been very clear about this. Okay. *5. If you have a follow-up question, press *5. All right. Let's go to question number 8. Just to give you an estimate, how many questions do we have? Usually about 14. 13. Yeah, I usually tell them to stop after 13, 14 so I can answer the remaining questions of people who are already here. So we have 13. After number 8, we have 5 more. Can an H-1B visa holder with an approved I-140 become a Virginia insurance agent? The answer is no. Okay. Can you become? Sure, but is that unauthorized employment? Almost certainly. PERM salary requirement for H-1B, corp-to-corp employment and prevailing wage. I'm currently working for a company on a corp-to-corp basis. My salary matches the prevailing wage requirement for my H-1B. However, when I inquired about the salary for filing the PERM, they said it should be minimally $120,000. My current salary is below the amount. So this is how you should approach PERM process. The difference between H-1B and PERM is, in H-1B we decide, the employer and the lawyers can try to triangulate which is the best level of salary and job title. We decide. In green card applications, the Department of Labor decides. So you should always assume the worst. So if you're a software developer, assume that they are going to give you level 4. But here is the interesting part. The difference between H-1B and green card salaries is this. When you apply for an H-1B, it is for a current job. Green card is for a future job when you actually get the green card. So let's say on H-1B your salary is $75,000 and you apply for a green card and government says, Department of Labor says your salary should be $120,000. That salary doesn't have to be given right now. That is only given when you get the green card. In the meantime, if you're on H-1B, same H-1B, $75,000 is all you need. It's a future salary. Press *5. Press *5 if you have a follow-up question on this. Okay. Next question, number 10. L1B, L2 extension and H-1B lottery, work authorization and salary considerations for L2 spouse. My husband's L-1B extension is in progress as a dependent. My L-2S visa is also in progress. We've got the receipt number. Can I work post I-94 expiration? I don't know. I have to look at the law. I don't remember it off the top of my head. There were some extensions allowed, but they usually end at the I-94 border. Okay. So that's to the best of my memory. I'm sorry, I don't know the answer off the top of my head. I will have to look it up. Should we proceed with premium processing? So the answer would depend upon this answer, right? Whether you can continue working. I don't think so. Most of these cases, I-94 based cases, but you know, L1, L2s are exceptions because L2 is employment authorization just because you have an L2. It doesn't require anything more than that. So I'm not sure I know the answer to that question. Okay. Have it double checked. And if you can continue working, then what is the point of premiuming it? Presently, you're in King County, Washington, salary is $100K. Will it be sufficient to apply for lottery? So lottery doesn't require a particular salary. The salary only kicks in after your H-1B is approved, which is at least after October. Okay. So I don't know what the salaries are. Salaries are available online. You can look them up and you can discuss it with the company lawyers. Press *5 if you have a follow-up question. Remember, to apply in the lottery, you don't have to be getting paid that amount. You can get paid, you can apply for the lottery even if you're getting paid $30,000. Only when the H-1B is approved, you've got to be paid that amount. Next question, number 11. F1 OPT, unpaid internship and H-1B. Misrepresentation charges. I've been with an employer for about 5 months during my F1 initial OPT. They provided an offer letter to stop the 90-day unemployment clock. This has been submitted to my office DSO, into my school DSO, and entered in the SEVIP portal. However, I never engaged in any sort of practical training. So that's basically misrepresentation. Then later on, you got a full-time job at an MNC. They filed an H-1B, which was approved. Will I be charged with willful misrepresentation? Yeah, probably. If it comes up, it can become an issue. And any willful misrepresentation is a permanent bar from entering the US. So that risk is there, no question about it. What are my chances of approval for an F1? I can't predict. If this issue comes up, you've got a problem. Press *5 if you have a follow-up question. Press *5. Okay. So this is the second last question. Multiple H-1B registrations in 2021 and H-4 EAD application, travel risks and port of entry. In March 21, I got the H-1B lottery registration, or I applied for H-1B lottery registration with 5 different employers. Got picked for one employer, but they decided not to proceed with filing. My wife is having H-1B. I'm planning to travel. So now you're on H-4. Is there a risk of investigation? Well, you never got an H-1B, right? So I'm not sure there is any real risk here. And I don't think it's really going to cause your EAD denial. And I doubt if there are going to be any issues at the port of entry. These are my guesses. Nobody can guarantee one way or the other. But because you never received an H-1B, and remember, even prior to the current situation, multiple entries were not forbidden. Multiple entries with collusion were forbidden. So if company A, B, C, D, and E, 5 employers apply for you, as long as they're not colluding with each other, and they're all separate employers with no connection at all, you could do that. That was allowed. Okay. *5, if you have a follow-up question, press *5. Okay. No follow-up. This is the last question that was posted. H-1B petition approved with incorrect Worksite postal code. What are the potential issues? I got my 797 and H-1B petition approved, but I noticed that the postal code for the Worksite was of another office. So it is that problem is on I-129. I think it's a relatively small issue. I think it should be okay, but you should bring it up to your lawyers and see if they can do some kind of a correction inquiry with the USCIS. At least they should try to get it corrected if they can. Because I think the address is all correct, only the postal code is wrong. To me, it appears to be a relatively minor error. Press *5 if you have a follow-up question. Oh, okay. From area code 619, which is California. California, I hear you. Go ahead, please.
Hi, Rajiv, sir. Thank you for taking the question. So would you recommend, like you said, bringing it up with the lawyers at my company? It's not going to cause an issue for me or my job, right?
It's not.
If I bring it up to them?
Well, I certainly don't. I mean, I don't know what the culture of your company is. They should want to correct these errors as much as possible. And if I were the lawyer, I would tell the company and you the same thing, that I don't think it's a big issue anyway. But we'll try to see if we can get it corrected. Because we made the error. The lawyers made the error, right? So we'll try to get it corrected. Okay.
Okay. So that would be like an H-1B amendment petition, or what would that be?
Well, it could be an H-1B amendment, or it could just be a correction without any amendment. So sometimes you can get these typos corrected. So they should reach out to the USCIS customer service, see what is the best foot forward. Okay?
Okay. And this wouldn't cause like the petition to be revoked by any means?
No, it should not,
Like
because I think it's a minor typo. In my view, it should be fine. All right?
Okay. Thank you so much.
You're welcome. Okay, folks, I think we are done with the posted questions. I actually see one of our clients, one of our corporate clients online from California. I'm not sure why you are here, because you can just access me directly. But if you have a question, you are in California. If you have a question, let me ask you to press *5. So you are a multinational company, and Yugandhar is your one of your HR people. If you have a question, press *5. All right, I guess not. Press *5. Anyone with any question, press *5. So it's, as I had estimated, that it's going to take me about half an hour to answer these questions. It's exactly 31 minutes. So that's good. We have plenty of time now. I only have 3 questions. Wow, that's easy. Let's start with area code 510, California. Let me see, where is I-510? Okay. 510, I can hear you. Please go ahead. 510.
Hi, Rajiv. So my question is, so my employer is running my payroll, but he's running not on the, like if I say, for Jan month, he's not running on January. He's running on February 15th. So the thing is, like, he's taking a gap of some time and running the payroll. So if I have been laid off, so that means until September I was working with him. So he's like trying to run my payroll for the September on November 1st week. How could I see the cycle of getting my 60 days time period for that?
So let me understand. They were paying you next month for the last month.
Yeah, true.
That's how it is, right? So this is what I would do. Look at the paycheck. Mm-hmm. It tells you which period is covered. Mm-hmm. Look at the paycheck.
Yeah, true.
It tells you which period is covered. Mm-hmm. That's the period you want to look at.
So if it's like until September, that's paid. From September, that means from October 1st, I'm on my grace of 60 days, right? October and November.
You were paid in November for October?
Yeah, for September I was paid. On November 1st, I was paid for the September.
And when did you get paid for October? Has that not been paid yet?
No, it's going to be paid by November end. Or December starting, they will be paying me.
So your 60-day grace period will begin at the end of October, right? Because you'll be paid for all of October, right?
Yeah.
Yeah. So it will begin the day after your pay period ends, which will be all of October. So November 1st, I'm assuming.
Mm-hmm.
All right.
Okay. So, yeah. Another question is like, I have got my PhD admission for fall 2025.
Ji, ma'am.
So, as I previously asked, the transition is like, is that going to affect me anyhow because of the new government that is going to come in?
I don't think so. I don't think so. What does that have to do with Trump? I don't think that has anything to do with anything.
So, so it's not going to even hurt me in my long
Ma'am, I'm not an astrologer. I'm a lawyer. Okay. I can't predict what the future is going to be, but I see no reason why you should be affected. Okay.
Okay.
Yeah. So nobody can tell you what the future holds, but we can make guesses based upon what we know. But you can't You can't expect us to tell you what the guaranteed future is going to be. Okay?
Yeah.
You'll be all right.
One last question after this.
Yep.
So if my if any of extension got delayed or it didn't happen as it expected, so I should be leaving the country, getting the stamp of F1 visa, and I can come in back, right?
Well, ma'am, it depends what the situation at that time is. I again don't know. Not being an astrologer, I can't predict what 6 months from today looks like. We'll have to see. Right now, we don't even have a formal statement of what they plan to do. So we'll see.
Okay.
Just sit tight. There is suspense here, just like for everybody else. But as far as change of status is concerned, I don't think that should be affected. Visa stamping, I can't predict. Okay?
Okay. Yeah.
Good luck, ma'am.
Thank you, Rajiv.
You're welcome. Okay, now next to Florida, area code 352. Go ahead, please.
Hi, Rajiv, sir. So, to give you some context, my H-1B petition is pending with USCIS. My question is, if in case I receive approval for this petition, then what will be my start date on I-797 form? Will it be 1st of October or, the date of approval of the petition?
Okay.
Yes.
You were selected in the second lottery.
I was selected in the first lottery this year.
So you filed in June, is still pending.
Actually I got an RFP on that.
Oh, okay, that
my
makes sense.
employer, has
So,
worked and responded to that RFP.
So they're not going to approve it retroactively. Typically, my experience is that they will approve it going forward. So if the case is approved on December 1st, your H-1B will begin on December 1st.
Okay.
Okay.
Yeah.
And
Okay.
and
Yeah.
if there is
And,
if there is a gap between your H-1B approval and your prior status, that should not be a problem.
Sure thing. Yeah. And a follow-up question to that is, since you mentioned, for example, December 1, then from December 1, do I get 60 days to, start working with my employer, or do I have to start as soon as possible with them after 1st December?
So people who are in the United States, they can request accommodation and they can join up to 60 days should not be a problem. If you are outside USA coming in, typically 30 days Department of Labor thinks is okay. But if you're already in USA, joining within 60 days after approval is not a big deal. Okay?
Sure, thanks. But is there a ceiling to it or a limit to it?
Actually, there isn't. There isn't.
Yeah.
Actually, there isn't.
Okay.
So I'll give you an example. We have a client who wanted to join 7 months after approval. Okay. What was the reason?
Okay.
He was finishing up a project with the old employer. So he sent out a written request, which is what we suggested, sent out a written request to the HR of the new company, and they signed off on it saying, okay, you can join us 6 months or 7 months from now. And that's fine. The employer, see, here's the interesting thing. The employee can ask for delay. The employer cannot delay. If the employer says, join me in 7 months, that's a problem. But the employee says, I can't join you until 7 months from today, that should be okay.
Okay, I see.
Okay.
Yeah. So that's all the question I had.
Yeah.
Thank you, Rajiv.
Good luck, sir. Good luck. Last question for the day is coming from Florida. No, California. 559. Well, there's one more after this. California, go ahead, please. 559, go ahead.
Hello, Rajivji. I have a question. Do H-1B visa holders are eligible to take sabbatical leave?
That's a tricky.
Professional development or anything?
That's a tricky question. If they take a sabbatical leave, are they in status while they are on that leave? I am not sure I know the answer to that question. Definitely, if you take a leave for medical reasons, that's acceptable. Now, this is where there's a difference in the Department of Labor and the USCIS regulations. I don't remember USCIS regulation says it's okay to take time off, for example, to prepare for an exam. But Department of Labor says that's okay. And they say it's even okay to take leave for tourism. For 1 month, I want to go in a camper and go from state to state. Department of Labor says that's fine. Typically, USCIS should accept the Department of Labor's interpretation, but they're not bound to. So I don't have clarity on this because there is no clarity as far as I know. Medical reasons, definitely. Sabbatical for gallivanting, probably not. Okay?
Okay. So just in case, in the long run, like when I do my next H-1B extension, does this reflect during that time?
Well, so let's look at it from the top side down. What is the worst they can do? If they say, well, you've been out of status, they can say, okay, here is the H-1B approval, but you cannot start working until you go outside and come back with an H-1B visa. No big deal. Okay?
Okay.
Good luck.
Okay. Thank you.
You're welcome. Last question from California, area code 909. California, go ahead, please.
Yeah. Good afternoon, Rajiv.
Good afternoon, sir.
I'm Dhaval. Yeah, I'm Dhaval. If you remember, we talked yesterday on the LinkedIn regarding transferring my case, change of status case to another location, another field office. So I tried connecting USCIS customer service multiple times. One suggested I can request Vermont center. This is which is my current center. To request change my service center from Vermont to California.
They won't accept. No, wait a minute. You can't choose the center you want to get your case processed in. But here is how it works. Government can redistribute cases based upon the individual workload in centers. Okay? You cannot ask the government to transfer your case to the center of your choice. When you file, you have to file according to the instructions for your location. But after that, they can still move the case to another center if they want.
Okay.
Okay.
So it can't be possible, right? Because I'm getting multiple different hassle from customer service, and I'm trying to connect with higher.
Yeah, I told you, na. I told you you can try to tell them, look, I'm getting different answers. I want to talk to one level up officer. They are the adjudications officer. They can tell you, unless the case has been transferred in error, they are not going to make you to grant your request. Okay.
Okay.
But no harm in trying.
This is the issue from.
No harm in trying. Let me ask you one question. What kind of application do you have pending?
I-539 change of status.
Okay, so that is your personal application. Yeah. So you can certainly request the government to that your case has been transferred. Looks like an error. Let the officer tell you. Okay.
Oh. Okay. Okay. And is it advisable to request them for the transfer? Because I don't know will it impact negatively or not?
No.
Just do the premium.
It's a genuine request. Yeah, if you want to do premium, that's even better. That saves you all the hassle. Okay.
Okay. Okay. Yes. Thank you so much.
You're welcome, Ji. Good luck. All right, folks, it looks like that's it for today. I'll see you again next Thursday. In the meantime, don't worry about what happens, what doesn't happen in the immigration field. There is a lot that is undecided until we see what the new government is planning to do, which will be after January or so. There's no need to worry. And then we'll deal with one thing at a time. Okay? Good luck, folks. Bye-bye.